Hello and welcome to this legal webinar. My name's David Spires and I'm one of the partners here at Hawkswell Kilvington. And I'm joined today by Rebecca Jackson. Becky is one of HK's legal directors. Our webinar today is focused on consequential loss. And as the title implies, this is an area that's often misunderstood. And with some potentially adverse results for clients. In the first part of the webinar, I'm going to be talking about the legal definition of consequential loss as it's understood by lawyers and the courts. There's an important distinction to be made between direct loss and indirect and consequential loss. And we'll be exploring that in a little detail. I'm then going to hand over to Becky for the second part of the webinar, and she'll talk to you about the practical application of those principles I'm going to highlight, with reference to some case law, and in particular looking at the limitation and exclusion of liability for certain losses, including, most relevantly for today, consequential loss. So, Becky, if I was to ask you what you would understand by the meaning of something that is a consequence or consequential, what would that suggest to you?
I suppose in everyday parlance, that would probably mean the result or effect of something.
I think that's right, of course. It's just simply a result or an effect. There's no real qualification in the ordinary run of things. However, at law, the meaning of consequential loss, is far narrower. And this was explored in a Court of Appeal decision, British Sugar and NEI Power. And in that case, the Court of Appeal looked at some earlier Court of Appeal decisions, a line of authority really, and they reached the view, essentially, that this question of what is meant by consequential loss and how it should be defined had been decided definitively and authoritatively by the Court of Appeal at an earlier date, and that they were bound by that decision, and that, in essence, the law in this area was settled. And the conclusion they came to was that, at law, consequential loss is held to be synonymous with indirect loss. Now, I know what you're gonna ask, Becky.
And what do you mean by indirect loss?
That's the next question. So, let's have a look at that, shall we? So, this question of the distinction between direct loss on the one hand and indirect loss on the other was first explored in and I can see you grinning, Becky, because this is probably the first case you looked at law school.
It's definitely an old favourite from law school, yes.
It's a very well-known Victorian case, Hadley and Baxendale. So in this case, Hadley was a mill owner, and he paid Mr. Baxendale 2 4 in old money to transport a broken crankshaft from the mill to be inspected by engineers that Hadley had engaged to make a replacement crankshaft. And there's a litany of delay and in delivery, and the knock-on effect of that was that the new crankshaft was delayed and Hadley's mill was essentially taken out of operation. So at first instance, the lower courts awarded Hadley £50 loss of profits, a substantial sum in those days. And on appeal, because the case proceeded to appeal, Baxendale argued that he hadn't been aware Hadley would suffer any particular loss or damage as a result of the delay in delivery, if there were to be one. So the essential question that the higher courts were asked to grapple with was whether Baxendale, in effect, ought to be held liable for damages he maintained he wasn't even aware of, or whether Hadley's claim for loss of profits, conversely, should be regarded as too remote to recover damages at law. So let's see how the courts decided this. So in what became known as the first limb of the rule in Hadley, or simply the first rule in Hadley, the court declined to award Hadley damages. It found that he'd failed to mention his special circumstances to Baxendale in advance. And in the absence of those special circumstances, the court held that Hadley's only entitlement was to damages arising naturally from the breach of contract. That is to say, losses arising in the usual course of things, or which might reasonably be supposed to have been in the contemplation of both parties as the probable result of the breach. And following the decision in Hadley, these are now referred to variously as general or ordinary damages, or as direct losses. Contrast direct losses then with losses falling under the second limb of the rule in Hadley, that's to say indirect losses. General damages, direct losses, must be contrasted with losses which don't arise naturally from the breach of contract, but instead arise from the special circumstances of the case. Now it's still the case that those special damages need to be known to, or should be known to, the parties at the time they enter the contract. But really, these are going to be exceptional or special losses. And those are how they're now referred to, either special damages or indirect losses. So that really is an explanation of what is meant by indirect loss. And we've already seen that consequential loss will be held to be synonymous with that. Contrary to popular belief, most losses that are debated in cases we see from day to day, they're usually classed as direct loss because they're the ordinary, normal, predictable results of a breach. It's not the case that special damages are particularly frequent. So just looking at one area in which this popular misconception is often seen is in regard to claims for loss of profits. Loss of profit claims are often thought of as being indirect or consequential claims, whereas in fact, loss of profits can be classed either as direct or indirect losses, depending on the particular circumstances of the case in question. And in most cases, at least some measure of loss of profit will qualify as direct loss. And this distinction was illustrated in another well-known case, Victoria Laundry and Newman. In Victoria Laundry, the laundry company claimed damages from an engineering company for a delay in supplying a boiler. Similar facts in some ways to Hadley and Baxendale, I suppose. Delays in delivery. Direct loss of profits from the normal operation of the laundry business, that's to say those that could reasonably be expected from dyeing and laundering contracts if the boiler had been delivered on time and put to immediate use, those were recoverable. However, the court ruled that indirect loss of profits weren't recoverable, as loss of profits in question were derived from special contracts with the government, which the seller couldn't have reasonably known about at the point of contract. So that case illustrates well the difference between both direct losses and indirect losses, and how in the case of loss of profits, there may be both direct and or indirect loss of profits depending on the particular circumstances of the case. So really then, to bring together what I've talked about in this first part of the webinar, what have we learned? Well, I think the most important point to take is that at law, consequential loss is synonymous with, is equivalent to indirect loss. Next, that indirect loss must be distinguished from direct loss, applying the first of those two rules set out in Hadley. And that certain losses, commonly thought of as indirect loss, may, in fact, and indeed often are, direct loss. So, loss of profit, loss of goodwill, loss of use, loss of contract, these are all common categories of loss and will be subject to the same rules as those set out in Hadley. So that's all I want to say. I'm now going to hand over to Becky, who's going to explore how those legal principles are to be applied in practice with reference to some case law in the particular context of the limitation and exclusion of liability. So, Becky, I'll pass over to you now.
Thank you. So, Dave's talked about the distinction between direct and indirect losses, how consequential loss is likely to be interpreted, and any misconceptions regarding its meaning. But in a practical sense, why is that important? Why are parties concerned to limit their liability for consequential or indirect loss? We're going to briefly look at some of the practical implications of what Dave's touched on in part 2 of this webinar. So, why limit liability in the first place? It's inevitable that businesses will be concerned about protecting their financial health and mitigating exposure to risk. Therefore, as far as possible, a business will want to limit their liability and the risk of having to pay damages in circumstances where things go wrong. In the absence of a limitation of liability clause, then there'll be no limits or exclusions on the damages a counterparty can recover. And given indirect or consequential losses are losses that may be unpredictably large or open-ended and therefore essentially represent an unquantifiable risk, often parties will seek to exclude such losses with a view to providing greater certainty from the outset. This allows the parties to be clearer as to what's recoverable and what's not recoverable. And in the event of a breach of contract, they'll know what's going to happen. So it's a similar principle to the basis upon which parties might agree a liquidated damages clause, for instance. Lastly, given that insurance policies will often contain clauses excluding liability for indirect or consequential loss, it's preferable that the construction contract itself reflects such exclusions so that a party is not being exposed to risks which it might have been unable to insure against. So what can you limit or exclude? Well, the general rule is that law supports freedom of contracts, so you can pretty much limit or exclude anything except where it's expressly prohibited by statutes or under common law. But notwithstanding that general principle, a clause which seeks to apply a blanket exclusion on all liability or virtually all liability that would arise under the contract is likely to be construed as void or ineffective, and that was made clear in the 2013 case of Kudos Catering, which we've referenced on the slide here. We'll come on to the Unfair Contract Terms Act 1977, which also applies a reasonableness test in circumstances where a party might argue a limit of liability clause is unfair. So there are some absolute prohibitions on what you cannot exclude under statute and common law principles more generally, and a number of these are set out on the slide here. But for current purposes, it's worth just bringing your attention to the 5th bullet point in relation to the Defective Premises Act, because certain exclusion clauses might not be capable of being relied upon for the purposes of excluding any liability arising under the DPA. And this area is somewhat of a hot topic in the construction industry at the moment, not least given the impact of the Building Safety Act in extending limitation periods under the DPA. But that's probably one for another day and something we've covered in recent HK seminars, isn't that right, Dave?
Well, indeed, we're about to examine that again at the UK Reef Forum.
Okay.
So yes, very, very topical.
Yeah, one to watch out for. So moving on, UCTA, how does it work? So as I mentioned, the application of the Unfair Contract Terms Act 1977, so UCTA, is also relevant in the context of a provision being made by parties to limit or exclude liability. There is a common misconception that there's some kind of general fairness requirement that applies to contracts under English law, but that's not the case. As I alluded to earlier, parties can agree what they like in the majority of cases. So UCTA is only concerned with the exclusion clause itself and doesn't examine whether the contract is generally unfair. An exclusion clause is not fully defined in UCTA, but can include any clause attempting to restrict or exclude liability, make a liability subject to restrictive conditions, or in some other way restrict the rights and remedies of the wrong party or restrict rules of evidence or procedure. So there is a risk that if ill-considered or drafted incorrectly, that certain attempts to exclude liability can be void in its entirety, for instance, where there's an absolute prohibition, or it could be void where it fails a test of reasonableness pursuant to UCTA. Different provisions of UCTA will apply depending on which type of exemption clause is used and on whether the other party is a consumer or whether it's a business-to-business contract. More commonly, of course, construction contracts will be concluded between two businesses. And as far as business-to-business contracts are concerned, UCTA kicks in where a contract is governed by a party's written standard terms. In other words, where specific terms have not been separately negotiated. So while standard terms are much rarer in in a construction context, we probably see them most commonly adopted for consultants upstream, for instance. It's still something to be alive to. So, with a view to illustrating some of the principles we've just discussed, I'll run through a couple of case law examples. The first of which is GB Gas Holdings Limited v Accenture. This case involved a contract relating to the design, supply, installation and maintenance of a new IT system. Unfortunately, that system was fundamentally defective and customers weren't being billed properly. In fact, the gas distributors were not given accurate usage data either. As you can see on the slide here, the contract sought to exclude liability for any losses, damages, costs or expenses whatsoever to the extent that these are indirect or consequential. However, the clause did not exclude liability for extra payments to suppliers, which equated to £18 million, cost of writing to customers and making voluntary compensation payments, which equated to £8 million, and extra bank charges for increased borrowing due to the reduced revenue caused by the system error. That equated to £2 million. You might mistakenly have thought that all such losses would be interpreted as indirect or consequential losses, but in fact, the court found all such losses, including the ex gratia payments to customers, to be direct losses falling within the first limb of Hadley and Baxendale. Accenture, in this case, should have expressly excluded these types of loss and could have sought to do so had they properly considered the drafting of the clause. Moving on to the next case, so Polypearl Limited v Eon Energy Solutions. This is another example which puts the principles we've discussed into context, and this was a contract for the supply of polystyrene bead and adhesive products. In this contract, it contained an exclusion of liability for any indirect or consequential loss, both of which include, without limitation, pure economic loss, loss of profit, loss of business, depletion of goodwill, and like loss. So Polypearl brought a claim against E.ON for its failure to buy the agreed quantity of products, and it had advanced a claim in damages for loss of profit.
I think, Becky, what's clearly happened here, this infelicity in the drafting, this has arisen as a result of a lack of a clear understanding that loss of profit might well prove to be direct rather than indirect loss. And I think, there seems to have been something lost in the understanding there, and that's fed its way through to the clause. Yeah,
and that often happens. So as you can see, had the clause been drafted differently and separate heads of loss been dealt with, for instance, by way of separate sub-clauses, the court's interpretation might have been very different. So that was a quick canter through some of the key points of principle in this area. The upshot is to carefully consider your limitation of liability and exclusion clauses. Parties are often caught out and think they'll be interpreted differently than they actually will be in reality. Ideally, specialist advice should be sought from the outset, but to assist you, there's some pointers on the slide in terms of best practice. So just to quickly run through those, you should be listing the specific heads of excluded loss. This can avoid loss of profit, for example, only being excluded if it's indirect, which, as we've discussed, can be a common mistake. Try and avoid generic references to consequential or indirect loss. Dave has run through how such terms are likely to be interpreted. And if you want to exclude a particular type of loss, then say so, and say so in clear terms. Parties often get muddled and confused when a dispute arises because of conflicting interpretations arising from use of unclear language. Finally, if you want to be able to recover a specific type of loss, consider including a clause which acknowledges that the parties are aware of the likely loss and that it's direct and it is recoverable. So hopefully that was helpful. Dave, I don't know if you've got any final thoughts before we conclude.
No, I think hopefully this webinar will prove useful in bringing about a greater understanding of the nature of consequential loss, its meaning at law, and how those legal principles are to be applied in practice in the clear and cogent drafting of exclusion and limitation clauses. Because certainly the clauses that tend to cross our desk often leave a little to be desired, unfortunately.
Unfortunately, yeah.
We hope you've enjoyed that webinar. Thank you.
Thank you very much.